Okay, ladies and gentlemen, gentlemen and ladies and gents, we have to talk about the new document. I've already received several emails, several phone calls of people talking about how that document is exactly what they needed. However, what I haven't done is I haven't explained to you the psychology behind the document. So, I was getting ready to play some music, but we're going to do this without music because I need to hold on to you all's attention. There are two videos being put up ahead of this one. They'll be all put up at the same time because I will upload them now, and then I have to add the description and the tags to it. So you'll have to pardon me that it will be a couple of hours before I'm able to turn on the computer and do all of that stuff. But I am uploading the other two now as we speak. One of them is already uploaded. It's just not set for viewing. Let me give you the logic behind the document. So the first thing we're going to do is we're going to go to tick tock, tick tock, tick. What I want to do is I want to go here. And what I want to do is this one right here. It says Federal Complaint Form PDF. Now I don't care about motions and all of that stuff. But I want all of you to pay attention to this because let's do California Small Claims Court. Hold on. Just want you all to pay attention. We're just going to go to the Small Claims Court. And then I'm going to have you go to the federal court and go to their forms section. Notice how all of their forms are in PDF format. Go ahead. Notice that none of their forms are documents. They're all PDF. Fill in the blanks. They already have everything already written out. We're doing the exact same thing. Why is that? Well, first of all, the first thing the court says that you failed to state a claim by which relief may be granted. They can't say that with this document because not only are you stating a claim, but you're also providing proof. Pay attention. You're also providing proof that this has been the common understanding of the courts. Just that simple. So now that you're providing proof that it's the common understanding of the courts, and I know I'm not going to find nothing here, and nobody cares about squabble. Who cares about squabble? I didn't ask for no squabble. I asked for small claims court. But this is Squabble app. Nobody asked for no Squabble app. Okay, so this is just a website where somebody is telling you about claims, but when you go to the court, you all have been to these courts. You've all been to these other websites where they have you fill out a PDF. Ladies and gentlemen, if you notice the complaint form with the judge, pay attention. And other officers of the court, that includes the deputies and the clerks and the deputy clerks and the deputy officers, police officers, marshals, otherwise. They violate your right during the due process. Go back and reread the Fifth Amendment. No one can be denied due process of law. No one, no persona, whether they are a legal fiction or a natural person, pays them attention. Oh, get out of here. No, I don't want to reply. I don't want to reply. How do I get rid of that? It don't want me to get rid of it, y'all. Let me get back to the conversation. When you are doing the documentation, when you're filling it out, it has a notary section. You cannot put your signature in electronically. You have to handwrite your autograph in front of the notary. Get it notarized, ladies and gentlemen. It is 11 pages. It has a simple jurat. If the notary says, oh no, we don't want to use that jurat's too simple. Okay, then give me your jurat page and we'll just attach it. How's that? But I'm going to sign it here. Okay, Don't cross out my jurat. Just say see attached. But do not cross out my jurat. You don't get to nullify my document by crossing anything out. You will put see attached. You guys understand what I'm saying? No lines, no crosses out unless you do it. Just that simple. Okay. Now you know why PDF format. And I was always going to do a PDF. I just had to do the document initially. Now, as I said, normally a document is just a bunch of words where people say this and people say that. Well, guess what, ladies and gentlemen? We're not doing a bunch of words where people say this and people say that. We're not doing that. We're not doing documents where people can just add all kind of junk. And you guys are reptilian creatures that are from outer space. Because we know that people have different beliefs. People have different understandings. That's why we put in there that you cannot sit up here and penalize me because my beliefs are not the same as yours. Doesn't matter what I believe. What I believe has nothing to do with anything. And you cannot use my beliefs against me because the law says that I have a right to believe whatever I choose to believe. Okay? That's what we're doing. That's how we are getting things done. That's how we are bringing things to people's attention. All right. I can't do this for much longer because I have a consult in less than 45 minutes. But we're going to go ahead and finish explaining to you how we're doing that document. Uh-oh, I definitely got to put y'all on hold, so y'all excuse. Okay, ladies and gentlemen, now I did forget where I was, but I know where I was headed. The individual I just spoke to is an incarcerated individual. That's why I had to take the call, because those individuals, when they call me, they get my attention, okay? Because they deserve it, because I've been where they are. I know what they're going through. Now, we live in a society where nobody wants to forgive people. Everybody wants to hold somebody accountable. They want to make sure that they're taken to justice. Yeah, that's a nice novel concept. Let's start taking the people who are taking people to justice. Ladies and gentlemen, let's do that because I think it is necessary for us to do that. It didn't like that. Okay. Now, no person shall be held to answer. Now, we're going to skip all this other junk. Okay? We're going to go straight to the text. But we're going to skip all the other junk in the middle because that is not applicable. We don't care about capital or otherwise infamous crime. We only care about any crime because a person being held for something not a crime, well, that's kidnapping. Kidnapping is illegal. No person shall be held even to answer. Okay? So, ladies and gentlemen, I do need you guys to understand something. What you don't know is that if any of you have ever had an arrest warrant issued for your arrest, where somebody went to the court and the court found that there was probable cause and ordered your arrest, then you are no person. See, no person is who you want to be because no person is the one who has the right never to be held for anything. You want to be that no person. Now, if you commit a crime, then yeah, you have to go through it, but you have to receive due process. Due process means they have to follow the law. That's what due process means, that they have to go through the process, but they have to follow it. Let's continue. Let's skip all the stuff in the yellow, with the exception of the beginning. No person shall be held to answer or to be twice put in jeopardy. Really? Nobody can be put through jeopardy twice. Alex Trebek is going to be upset. Nor shall they be compelled in any criminal matter. Doesn't matter even if it's treason, to be a witness against themselves. So why is it that in every single case they use your photos, your fingerprints as evidence against you? You're now being compelled to be a witness against yourself. Well, you volunteered to give us that information. No, because when I told you no, you said that I wasn't going to get this and I wasn't going to get that. You made it conditional. So at that point, it was you compelled me. Nor be deprived of life. How many of you have lost loved ones because somebody thought they had a gun, or somebody thought they were reaching for something, or somebody thought that they had a suspended license? Or be deprived of liberty. How many of you have been placed in jail, like that young lady in Alabama who the judge put her in jail for 1.5 years for parking tickets? Ladies and gentlemen, parking tickets are a debt. You can't be put in jail for debt. There are no debt prisons in America. Don't believe me? Go back and look at what a parking ticket is. It's a debt. Sorry about that. Or be deprived of property. How many of you have had your property seized and taken by the police department, by the courts? I was talking to a guy. They've taken his computer and everything else. Taken. They haven't given it back. They've had enough time to copy everything. So why are you still holding on to my stuff? Without due process of law, nor shall private property be taken for public use without just compensation. Now, you need to understand something here. You notice it just says, nor be deprived of life, liberty, or property. So you already couldn't be deprived of property, but then they added, you see how they have the colon? Nor shall private property be taken for public use. Ladies and gentlemen, you do know that that was added there. Without just compensation. The government never had authority to just take somebody's property. The right to property in America is absolute. Eminent domain was never the right of Congress. The public never gave them that right. Everybody keeps talking about sovereign government. The government is a government of the people. It may be sovereign, and like I said, I have no problem with government. It is not government that is bad. It is the people in government that is bad. You don't believe me? When was the last time government has ever violated your rights? Go back and take a look at the code. It says any person who deprives an individual of their rights. Government can't do that. It is the people who do that. So government is fine. Government does what government does. The government has never violated a single person's right. It is the people in government who have done that. It's the people who violate their contract with each other. Go back. Declaration of Independence. The people have devoted their lives and their fortunes. Now, ladies and gentlemen, we showed you this, but I got something else I need to show you. I think it's going to be equal power, or is it going to be this one? I think it's going to be this one. I think not equal power for every dollar, because we're going to talk about that in a different video. But for right now, we're going to talk about this. This talks about the law has not made the notice standard value greater than the coin. Now, the reason why I'm showing you this, the legislature have not provided specific limits on the discount rate for such transactions. Don't care about that one. The statute does not define the term actual value. Now, why is that? Because Congress gets to determine the value of currency. Give me 1 second. Sorry, I can't go into detail as to what I wanted to go into detail because that call took a little bit longer. Individual having a tax problem with the county. Look, I've told all of you. You all need to pay attention. It's called the use tax exemption form. It may not be called exactly the same thing in every single state. It may be worded differently. but it is a use tax act. That's how they're taxing you on your private property. We just read the Fifth Amendment, which specifically highlighted that no person can be deprived of life, liberty, and or property without due process of law. They cannot deprive you of your right to live, your right to own property. These are due process rights. Nobody can take that from you. Congress cannot tax you on your guaranteed rights. They have no right. That's what the Fisher versus Redfield case was all about when they said Congress cannot impose an excise on the individual person and on their property because those are essential rights. Congress has no jurisdiction. The courts have no jurisdiction. Okay, if you have a private property, I don't care if you made a contract with the bank. It is not a secured loan. Go ahead and look up what a secured loan is and a non-secured loan. Put the fact of, just put the phrase, watch this. Got to do this real quick. Hold on. No, we can't do that. We have to do it here. Okay? Because this is the one I set up just for this conversation. So all you have to do is in your mind imagine what the court would say. Now, I don't care about the keyword search because that'll send me all over the place. The loan was made and could not be made by a federal land bank. Don't care about that. Neither a conservative loan nor a loan which obligated the alleged borrower to repay the principal. It was neither a conservative loan, which means it was not a secured loan. Okay. As the loan in this case was made in accordance with the building and loan statutes of Oklahoma, it was not a building and loan contract and was an ordinary loan. An ordinary loan, a personal loan. Please understand, the bank did not give you a loan for a home. They gave you a personal loan and you took the funds and acquired a home. Go back and pay attention to what was done. They do not have a right to foreclose on your home. I've already done too many videos on that. Okay. It evidently regarded its loan as inadequately secured or an unsecured loan. At least it was not such a loan as the state banking department would approve under the law. Apparently, however, it was not a loan to be characterized as a mortgage loan. Okay? Unlike here, the property was not collateral for a secured loan. Your loan was not a secured loan. As I mentioned, when you got the property, you didn't own the home. The loan was so that you could acquire the home, so you could not put the home up as collateral. It's called the forbidden fruit doctrine, the first in line, first in right. Okay, ladies and gentlemen, you could not put up a property for which you did not own, and you did not own the home because the bank gave you a loan to go purchase a home. That's why they say, okay, you've been approved for the loan. You've already got the loan. You've been approved. Then they give you funding after you find the home. They do not give you a home loan. They give you a loan to go acquire a home. Go back and pay attention to your paperwork. They cannot foreclose on the home because it does not fall under the foreclosure statute. Doesn't matter if they call it a mortgage. You just saw one of the cases where it said it didn't matter if they called it this or that. This transaction is not secured since the bank was not lending against the deposited item. Lord have mercy. Furthermore, the alleged loan was not a loan. Too many cases. Too many cases. Now, wait, hold on. I got one more thing because y'all know what I do. I give y'all more than what y'all bargain for. You sure do. And that literally gets on my nerves. I don't know why you think that that's important to me. Lord have mercy. Copy, And then we're going to open another one. And we just going to pasty. Yeah, pasty mother. Okay. We're just going to paste it in here right there. And then we're going to go enter. Nope. Don't care about any of that junk because that's not what we're looking for. What are secured loans and how do they work? Here's the difference between a secured and unsecured loan. Secured and unsecured loans. Do your research, people. Learn what a secured loan and an unsecured loan is. Been talking about this. So many people have talked about this. Y'all need to understand what a secured loan is. An unsecured loan, they cannot foreclose on a home, ladies and gentlemen. Differentiating between a secured and unsecured loan. Now, guess what? Watch what I do. See that right there? ... And then we put quotation ... Anyway, come on now, gotta go here. Then we bring you all the way there, and then we put my other quotation, and then we go enter. Okay, let's see what we get now. They still did the same thing. What are secured loans? What is a bank secured loan? What does it mean when the loan is not secured? Let's try what does it mean when a loan is not secured. There are two types of loans, secured and unsecured. Secured loans require that you offer up something you own, that you offer up something you own, that you offer up something you own of value as collateral in case you can't pay back the loan. Hold on, ladies and gentlemen. You can't offer up the home when you're getting a home loan because you don't own the home. You have to pay the seller first before you can put the home up as collateral, which is why they make you sign the papers and sign the closing docs after they paid for the home. You need to be challenging that process because it's illegal. It's illegal. Nobody challenges it, sir, because nobody has ever realized the process. Ladies and gentlemen, the reason why it's unsecured because you could not put up collateral for that home because what did they tell you? You have been approved for a loan valued at blah, 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 blah. Do I need to put up any? No, you don't have to put up any collateral. You can start looking for the home. They already tell you, which means they lied. The Truth in Lending Act means that they lied. They cannot lie about the loan. Whereas an unsecured loan allows you to borrow money outright after the lender considers your financials. Ladies and gentlemen, did they not consider your financials and say you've been approved for a loan? That's a standard loan. Go back and understand what's going on. Okay, I apologize, ladies and gentlemen, because there are a lot of people going through foreclosures, and we are trying to give them the information they need to undo all of that stupidity with foreclosures. Now, let's get back to the reality. The document, the complaint against judges, it is not as simple as it looks. First, it lists facts, but each one of the facts, it supports with their own case text from their own cases. So they cannot tell you that it's frivolous. It's a frivolous argument. They cannot tell you it's a meritless argument because you're showing them thousands of cases. Go ahead and look how we put the whole case text web page, which shows how many cases. Hold on, let's go back there for just a second so you guys can see. This is where the genius lies. Now, hold on. We're talking about this. This says 21 cases are recommended. Hold on now. Hold on. That's just 21 cases are recommended. Hold on. Just 1,000+ cases found in a keyword search. Do you follow what I'm saying? We give them the web link so they can go do their own research. It ain't our job to tell them the law. It ain't our job to tell them what their courts have decided. But what if the courts, they say, well, that was that, but that's a different circuit. It doesn't matter. It doesn't matter what circuit it is, ladies and gentlemen. The federal district court operates under federal law, not state law. Huh? The federal district court operates under federal law, not state law. Doesn't matter what circuit it was in. Doesn't matter what circuit the decision was made in. It was made by the federal district court. part of the supposed judicial branch of government. That's what matters, people. The government cannot contradict itself. The people haven't given it the right to do so. Go back and look at the Delegation of Powers Act. The courts don't get to say one thing over here and then another thing over there. Unless the issue is dealing with the state, unless they're dealing with a state issue, then yeah, they can do that. But not when it comes to federal law. Federal law has to be equal. Remember, justice is blind. Equal justice for everybody. So that's how you take care of that. Ladies and gentlemen, I got less than 10 minutes, so I do have to get started. There are so many other things I want to tell you about that contract, especially why we have the jurat at the bottom. But go ahead and take a look. You'll see the reason why you don't have to do anything else but type in your information. We are going to create one for the individuals who are incarcerated. So those of you who are incarcerated, give me a couple of days so that I can get one for you, because many of you do have access to the videos, or your family has access to the videos. This is me letting you know that you've always had a right to do an incarceration contract. You've always had the right to do an arbitration contract. You always had the right to do a implied consent agreement with government. They couldn't just make up a new rule. They want to come and attack organizations that I start. But the one thing they have never done is called me in the court saying I've done something wrong. Called me in to testify, because I have not hidden or run away from any of these people, any of these courts. But they know the first thing I'm going to do is challenge their jurisdiction. They know that's the first words that come out of my mouth. I hereby challenge your jurisdiction. I'm not going to just challenge one aspect of jurisdiction. I'm challenging every aspect of your jurisdiction. And if you're missing one, you have none. Just that simple. Those the words out of my mouth. Not just your personam, your in rem, your so-called subject matter. No, I'm challenging your jurisdiction. You are the one that has to have all of those other aspects. There ain't no law that says that I have to sit up here and be specific. There ain't no law that says that I have to tell you what my rights are. I'm sorry, I apologize, ladies and gentlemen. That's what's been going on. So if you look at the document, let's say they ignore you, because there is something someone showed me and I'm supposed to be showing you guys, and I don't know if I have it up. Dang it, I don't think I have it up. He was showing me something about a private attorney. Okay, private attorney general information. Ladies and gentlemen, there is a law, it's called the Civil Rights Act of 1866, that says that if you are the plaintiff and the United States does not want to prosecute the case, then you get to become a private attorney general. We haven't gotten there yet. I've already told you about the Civil Rights Act of 1866. Go ahead and see that it's quoted in the complaint, because Section 242 and Section 247 and Section 241, that's under the Civil Rights Act. That's why we're bringing that. The whole 1983 claim, 1985 claim, 1988 claim, that's under the Civil Rights Act of 1866. We are headed there. We're not there just yet. So please expect more information about the contract. We'll be doing it soon. I have to go because I have to give this person my time because they paid for it. Take care, everyone. Goodbye.